Lundy against the Queen.
Mr. Mando.
Yes, my pleasure, Lordships, my lady. I won't take the board through the respondent's case any further on the point of disclosure, apart to refer the board to the English decision of Ali Bahai's, which can be found at tab 5. In volume 1 of the bundle of authorities, and in particular at page 2987. At paragraph 62 of the judgment, commencing on the penultimate line, the court observes that material in the possession of a prosecutor is not disclosable simply because it is or might be relevant to an issue in the case, and then refers to Lord Bingham in Queen and H. If material does not weaken the prosecution case or strengthen that of the defendant, there is no requirement to disclose it. For this purposes, the parties' respective cases should not be restrictively analysed, but they must be carefully analysed to ascertain the specific facts the prosecution seek to establish and the specific grounds on which the charges are resisted. Neutral material or material damaging to the defendant need not be disclosed. In my submission, particularly in respect of the Rodriguez letter and the Doyle correspondence, the Rodriguez letter was in my submission neutral, and the Doyle letter, if anything, favoured the Crown's case. In my submission, there is an element of post-trial reconstruction as to the perceived relevance of Drs. Doyle and Rodriguez's communications. They originated at a time when the police were immersed in the exercise of locating an individual or laboratory which could carry out the required analysis which other experts said needed to be done, but which they themselves could not progress. There is nothing to suggest in any of the material that has been put before the board to suggest that Dr. Rodriguez would presently have been critical or negative about what Dr. Miller was able to achieve in his laboratory.
Are you making the same point about Dr. Teo and the document which we looked at the beginning of this hearing, tab 18 in the supplementary volume? This is the document that hadn't been disclosed. Now, we've looked through the notebook and we've seen a mention of his name, but what doesn't appear in the notebook is the critical passage at the bottom of page 320, which wasn't disclosed. Are you saying that that isn't within the umbrella of what was being talked about in the alibi case?
No, my submissions at this stage are limited to Rodriguez and Doyle.
Right.
I have made the acknowledgement
Yes.
that the finding of Dr. Teo ought to have been disclosed.
Right, thank you.
The submission that I made in respect of Dr. Teo was that, having regard to the way in which the evidence developed and the way in which the research of the point developed, Dr. Teo's opinion really could be put to one side because events overtook it.
Because it's based on the ESR slide.
Yeah.
Indeed.
Yeah. Yeah. But where is the evidence that explains why perhaps we've sufficiently covered this, but could you just remind me, where is the evidence that explains why the degeneration observed by Dr. Teo in the ESR slide would not also apply to the slides prepared by Dr. Miller?
Well, that fundamentally, that evidence resides in Dr. Temple Camp's affidavit, where he explains...
He's not a neuropathologist. That's the submission that's made there.
Well, he's not a neuropathologist. I haven't orally addressed the board on that point. It is included in the written case, but the respondent does not accept the criticism made by Dr. Whitwell that only a pathologist is capable of, only a neuropathologist is capable of discriminating morphologically between brain tissue and other tissue.
But that's what Dr. Pang said at the outset. We need one.
Well, that is the police officer's interpretation in the letter.
Yes.
One needs to be very careful in my submission of how the officer has described Dr. Teo. It is something that would need to be, in my submission, explored in evidence orally as to quite what is the distinction between Dr. Teo and Dr. Pang.
Dr. Pang gave them morphology evidence at trial, so he obviously thought he had the expertise.
The question of expertise was something which was actually put to Dr. Temple Camp himself in evidence.
Sorry, so just to be sure, the answer that you give to me is that it's Dr. Temple Camp's evidence that you rely on.
Dr. Temple Camp's evidence
I think the appellant's case on this can be stated quite shortly, because there are a lot of peripheral issues as to whether Dr. Rodriguez and Dr. Doyle came within the penumbra of neutrality. But surely the essential case made by the appellant is this. Dr. Teo's information to Detective Sergeant Grantham, at a minimum, would have alerted the defendant to the lack of wisdom in making a concession that this was brain tissue, and would surely have prompted more extensive inquiries designed to show, or at least raise a reasonable doubt as to the nature of the material. That, I think, is the essential case, stripped to its bare essentials, that the appellant makes. Is there any answer to that?
Well, in my submission, there is a direct answer to that, and that is that Dr. Teo's viewing of the ESR slide was of the ESR slide alone. The evidence of all the other pathologists that had viewed it was that they expressed a view, Pang and Temple Camp expressed a view that they think it might be brain. Dr. Miller himself, when he viewed the ESR slide, said it might be brain, but I can't be sure.
So you say that the board should reach the conclusion that even if the defence had seen Dr. Teo's statement to Detective Sergeant Grantham, it would still have made the concession?
Yes.
I see.
Because the defence went on to get the opinions of experts, Dr. Venices and Dr. Sinek, who is a neuropathologist.
Dr. Teo's point, though, was that a period of 59 days had elapsed. That's the problem he had with the ESR slide. And the prosecutor was presenting this case, as you'll recall, to the jury on the basis that the material was fresh and that there had been a complete disclosure. And that's, perhaps I'm just repeating Lord Kerr's point, that if the defence had known that it was not fresh, then that, that was certainly not their position at the trial, and it would have opened up, could have opened up further inquiries. Why not?
In my submission, there was no secret that the ESR slide had been taken 59 days after its seizure. There was no secret at trial about that. It was very clear, known, it was on the evidence.
But was the significance of the delay understood?
Well, the significance of the delay was the subject. The significance of the delay in my submission is a complete red herring. The 59 days is a complete red herring.
But only on the basis that this material is sufficiently fixed to enable morphological, or whatever that awful word is, identification.
That is correct, ma'am.
But the visual, if I can say it that way, identification is made, the neuropathologists who look at the slide say, the ESR slide say it's too degenerate. And my point is, you've got other slides that Dr. Miller has prepared. Who is the expert who's the neuropathologist who says that that is brain material from a visual examination?
Well, Dr. Sinek had all the slides, which included the... Well, in my submission, the evidence shows that Dr. Sinek was sent the Dr. Miller's slides. I'm sorry. It was sent the report with the photographs, not the slides.
Yes.
Dr. Venices, who is not a neuropathologist, was sent the slides.
Yeah.
So I acknowledge that. Your Honour's point about where's the neuropathologist that looked at the ESR slide?
No, because the ESR slide, I think, has been overtaken because there's so much doubt about whether it could be confidently treated as brain tissue. So now the only other option, this is leaving aside the IHC identification for the moment. My query is directed to Dr. Miller's slides. Is there something about Dr. Miller's slides that makes them different from the ESR slide? And who gives evidence of that? And I think you've said Dr. Temple Camp.
Well, Dr. Temple Camp's affidavit explains how different parts of the same sample can have different
Properties.
And different levels of decomposition.
Yes.
And as I say, the issue of Dr. Temple Camp's expertise to examine the slides is at page 1207 of volume 3. And in particular at page 1219.
1219. This is in the evidence.
Yes, ma'am. Volume.
Is he being cross-examined?
He's been cross-examined by Mr. Behrens.
Right. Yeah.
He's asked the question, who would be the expert and what is that expert's occupation who identifies what tissue might be? It would be a histopathologist. And is that what you are? I'm a histopathologist, yes. So it's because of your qualification.
I'm sorry, where are we talking? 1219?
1219. Right at the bottom.
Oh, the bottom, yes. Oh, yes, thank you very much.
No, I can't find it out. What line?
I'm sorry, right at the bottom of page 12.
Oh, I'm
the
sorry, I'm
bundle.
looking at the numbers at the top.
So was I, I'm
Yeah.
afraid, yes.
I'm sorry.
Yes, I've got it. So this is still cross-examination, as we can see. Yes. Who would be the expert?
He's talking there, isn't he, about the ESR slide. If you look over the page, you'll see that he says that he hasn't seen any other slides.
Yes.
Just check that I'm right. That line 15 on 1220, he hasn't seen
yes.
Miller's slides.
In fact, the previous, page 1217, he's asked about his own, this is about line 8, asked about your own examination of the slide from the ESR. They both, that's to say, Miller's report and the ESR slide both show tissue that is adequately fixed. In terms of preservation, both reasonably well preserved, and that indicates to me that they were preserved in a period of 30 minutes from expulsion from the body.
Sorry, what page was that?
That's 1217.
Yeah.
Yes, he's referring to the ESR.
What he's seen, well, he's seen, if you look at 1220, he makes it clear what he's seen, line 20. He's not seen any tissue from the murder scene other than this slide, that's the ESR slide, and he's seen the photographs of Miller's.
What does the word both refer to then?
Sorry,
The word both, what does it embrace? It's two smears, has it?
The photos of the slides from Miller and the actual slide, ESR slide.
that's right. Now, since then, Dr. Templecamp has viewed Dr. Miller's slides, and his affidavit is prepared, and he speaks of his
Mr.
observations.
Member, this cross-examination is taking place in ignorance of the fact that Dr. Teo has said that ESR slide is not capable of a definite identification. And in the light of Dr. Pang's, and in ignorance of Dr. Pang's view that they need a neuropathologist to nail this.
Well, firstly, two things. Firstly, it was clear that no one could make a definite diagnosis based upon the ESR slide. That was clear. That was on Templecamp's and Dr. Pang's analysis. So everyone was aware that there could not be a definitive conclusion as to the tissue based upon the ESR slide.
Well, he goes in chief at 1209. He's saying, well, I found there was tissue on the slide and it was adequately preserved, so I was able to recognise there were blood vessels present and cells present, and my initial diagnosis was that this tissue was brain tissue. So that's his starting point. Now, you're saying, well, he began to subtract from that, did he?
Well, in cross-examination, just have a moment. Just have a moment, my lord. So at page 1210, the top of the page, the proposition is put. And because of the way in which the slide was presented and what you understood to be the origin of the tissue put onto the slide, did you have some recommendations to make to Detective Grantham? Yes, I believe that this was brain tissue, and I believe that to prove that conclusively it would need to be prepared in a special way so that it was demonstrable beyond all doubt.
Yes. Yes. Yeah. And that takes them to Dr. Miller.
And again, referring back to page 1220, when he's being asked about his expertise, at the top of the page, and is that what you are, a histopathologist? Yes. So it's because of your qualification and your experience that you could look at this particular sample, if I can put it that way, and think that it was probably, central nervous tissue cell. Yes, that is correct. It would probably be fair, what I said at the time, there was a very high probability that this was brain tissue. But to be certain beyond reasonable doubt that it was brain tissue, you needed Dr. Miller's particular expertise. That is correct. And Dr. Miller himself, when he gave evidence, it was referred to yesterday, described as, when he looked at the ESR slide, he said it might be.
You what?
It might be brain tissue.
From a visual inspection?
Of the H&E stained ESR slide.
Sorry, Dr. Miller.
Dr. Miller.
Yes. What, can I? Oh, no, don't take time.
So if we can just have a moment, I just wish to... Yes, I'm sorry. The suggestion by Professor Whitwell that only a neuropathologist has the expertise required is a proposition that has been made in Professor Whitwell's second affidavit in reply, which has not previously been asserted.
Sorry, I missed that.
Which has not previously been asserted.
Oh.
Either
Except inferentially by Dr. Pang at the outset.
well, only in terms of what the police officer has put in his
Yes, I understand.
statement and what he understands Dr. Teogue is.
He's not saying I'm incompetent. He's just saying neuropathologist might be able to help.
and as my learned junior has said to me, Dr. Pang is not disavowing his ability, as indeed Dr. Temple Camp did not disavow his ability as a histopathologist to be able to discriminate between brain tissue and another type of tissue. So for the first time in the second affidavit, Professor Whitwell asserts that the identification of brain tissue should have been performed by a neuropathologist. Nothing has been cited in support of the proposition apart from the opinion of Professor Whitwell herself. And it does amount to an attack on the expertise and competence not only of the Crown experts consulted, but it does raise issues in terms of Professor Venice's expertise.
Yes. Well, I mean, he isn't a neuropathologist.
No, he's not.
Isn't it?
But he was asked the very question in a direct inquiry by the appellant, and perhaps if we can go to that, it's at the bundle, in the bundle at page 1836, volume 4 of the bundle. And he was asked about his ability to examine the slides including the H&E stains slides. And he states at the bottom of 1836, when I received the slides, I examined them under the microscope and was clear to my mind that they contained brain tissue.
Sorry, which slides is he talking about? Is he talking about the Miller slides? Or
We'll just get this clear. He was sent Dr. Miller's slides.
Well, it all,
Delivered as you may
suggests that he
recall.
did the Miller slides because he said, I didn't rely on the expertise of Dr. Miller, but examined the slides myself.
Yeah.
And you may recall the affidavit of Rowan Butler, who physically delivered the slides of Dr. Miller.
They were Miller's slides, were they?
Sorry.
I certainly remember the affidavit. They were Miller's slides, were they?
Yes, absolutely.
Sure?
I am.
There seems to be some doubt about it.
There does seem to be. Well,
well, that slide went from New Zealand, didn't it? The
it did.
The young lawyer who was fortunate enough to have a trip.
Well, perhaps we could go to the report of Dr. Venices himself. Page 1890, which he sets out what he received.
Oh, the page number 1890, so that's
1890.
that's the next volume, is it? No, it's the same volume.
No, same one.
Yeah.
One 1895, top of the page.
Yes. So he's looked at the slides under a microscope prepared by Dr. Miller's, including the H&E slide.
think they've all got H and E on, haven't they?
Yes. So returning to page 1836, in response to the inquiry made as to the ability of Professor Venices to undertake this examination, he states, when I received the slides, I examined them under the microscope. It's clear in my mind they contain brain tissue. As a pathologist, it is within my expertise to recognise the appearance of different organs microscopically, even when they have been smeared or distorted in some way. Occasionally, we all have difficulty in being sure, particularly when the samples are very small. However, as stated in my report of 6 March 2002, I was of the firm view that brain matter was present. I did not simply rely on the expertise of Dr. Miller, but examined the slides myself.
This is after, as has been put to us, he initially advised that although he was able to advise about the time of death and how the material came to be deposited, i.e. whether it was deposited fresh or smeared or whatever, he didn't feel able to identify the matter. And that's where he suggested Professor Graham initially.
No, in my submission I don't accept that interpretation at all.
Right.
Page 1870 in the same volume. Middle of the page. Dear Mike, Mr. Behrens, many thanks for the material which I have had an opportunity to read through. There are a number of forensic issues in addition to the straightforward issue of whether the smear is brain or not. On the latter point, on the face of it, it looks fairly certain that we are dealing with brain tissue, but the various ways in which it could have got there are worth considering.
I beg your pardon, which page was that?
1870.
70.
My lord.
Okay.
And then on the next page, I have a specialist available, Professor of Neuropathology, that would be willing to deal with the narrow issue of brain identification, but not how it got there.
Yeah, but is that or is that not, do you say, disclaiming his own expertise?
Well, in my submission, he's not disclaiming his expertise as a pathologist to distinguish between one type of tissue from another type of tissue. It may well have been thought that you get the imprimatur of a neuropathologist, and it is a mystery as to, we're still not sure quite what happened in that regard.
Is the specialist he refers to Dr. Graham? Is that the person he has
Yes.
in mind? Who never got to grips with this, did he? As far as we know.
Sorry?
Dr. Graham, as far as we know, didn't see the slides.
It would appear not. We cannot be absolutely sure because, as my learned friend advised, inquiries were attempted with Professor Graham, but were not successful. And if one goes to page 1874, clearly on the 6th of December, the plan was for Professor Graham to look at the slides.
Yes, I see.
So quite what has happened remains something of a mystery. Now, Professor Venices has not been invited to comment on Professor Whitwell's evidence that he is wrong and that he may have been conducting himself for a long period of his professional career in a manner beyond his expertise as a pathologist. In the email, he has set out that this is something he does regularly. and it is a challenge indeed to all the other pathologists' expertise. Professor Gatter is, of course, a pathologist. And I do make the strong submission that this was something that was not advanced in the appellant's skeleton argument at the leave stage, and the respondents and the respondents' experts have not had an opportunity to put this proposition to its own experts, or indeed to some professional body, to remark upon. It does need to be emphasised in my submission that what is at issue is the identification of normal brain tissue, not tumours or disease, or the interpretation of some injury to the brain. Clearly the latter requires the specialist knowledge of a neuropathologist, but the expertise to distinguish one type of tissue from another clearly does not in my submission. There is a risk of giving evidence from the bar, but the thought that a pathologist is a basic principle whose job it is, a histopathologist, to look through a microscope, is not able to discriminate between different tissues is an extraordinary proposition in my submission.
But it wasn't simply a question of is this brain or is it not. Dr. Miller was giving evidence, as was Dr. Temple Camp, to the effect that this was brain tissue that had exited the body only a matter of minutes before being deposited on the shirt. I mean, that's a really damning aspect of this chapter of evidence.
Indeed. And of course, we did have the contest at trial between Dr. Temple Camp and Professor Sinek, relating to the properties of brain tissue and how quickly they deteriorate. And that was very much a live issue at trial, which was gone into in great detail. This is where the other aspect of this is where there seems to be an extraordinary disconnect between Professor Sinek's evidence at trial and the affidavit evidence that she now proffers, which is basically that had I known that the tissue, I think she uses the word, had been left for 57 days or some such reference, is quite extraordinary in my submission. I can just turn to that aspect.
I just wonder the purpose of all of this. You said that there's an extraordinary disconnect between her evidence and her affidavit. How are we to judge whether that wholly nullifies her evidence? I mean, apart from pointing out that there is a difference, and a difference which may ultimately require to be resolved, does it assist to elaborate upon that?
Well, only I'm concerned that the board may place emphasis and weight on Dr. Sinek as a neuropathologist in her reference to the 57 days, which as being something that she wasn't aware of, when she gave evidence at trial on the very thing that she now disavers knowledge about, which is about how long can you get a GFAB reaction, how long can you properly apply dyes to tissue which is unfixed. She said it could go out to 3 days. Her evidence was that she accepted that the sample was well fixed. She gave evidence at trial accepting that air drying thin smears of tissue functions to preserve them, acknowledging that that's a technique that is used by surgeons during brain biopsies. Perhaps it is worth going to her evidence. The notes of evidence, it will be volume 3 of the bundle at page 1238. No, that's not the right reference, I'm sorry. Bundle at 1385.
This is in cross-examination by the Crown, isn't it? Starts at 1376.
Yes. Yes, my lord.
What are we to take from what we see at 1385? Obviously, time is of the essence for the surgeon deciding what steps to take from then on. And
yes, line 20.
Yes, I mean, that's all part of the surgical process, but does she expand on the significance of it for fixing?
Yes, she does. At page 1251, this is in her evidence in chief.
351.
I'm sorry, that's not the right reference. I keep referring to the evidence. 1387. And questions from the bench. Doctor, I just wanted to see if I could see what the differences between you and the other doctors is. There has been lots of questions just recently directed to the fact that the smear that was on the shirt was of a very small piece of brain tissue and that it was very thin and would have dried very quickly. Answer, yes. I take it you agree with that, or you accept that? Answer, once it has been smeared out, yes, I do, and that the doctors observed that it was extremely well preserved. The brain tissue was extremely well preserved because of it. Answer, yes. And they concluded that it had to have been smeared there one way or the other very shortly after leaving the body. Answer, and that is where I would disagree. So her evidence was how long could the tissue have survived unfixed and still be capable of producing a positive result when the IHC process was applied.
So she's on the possibility of subsequent, plant or perhaps accidental contamination.
Absolutely, my lord. She was trying to... Sorry.
Yeah, that's what she's addressing, is that she's assuming that it's fixed and identifiable, and addressing the question of how long after the murder it could have got onto the shirt.
Well, my submission she's doing more than assuming.
Well, no, accepting, you would say. Yes, accepting that it's identifiable.
Yes, because by this stage, the defence have decided we're not going to contest what the nature of the material is, and therefore the defence has to be that it got there other than by presence at the scene, and so the alternative is accidental or deliberate subsequent contamination, and so the issue of freshness then becomes critical.
At page 1398, there is a further reference, my lords, my lady.
But the point is, as I understand it, that by now she certainly does know that it's been, she knows the history of the recovery of the shirt. Is there any sign of her at any point saying, that means you've got to be very careful about, in fact, I can't see how it could have been identifiable, given that length of time?
No, there isn't.
She doesn't say that. I grant you that the concession's been made by then, but... Right.
At page 1398,
Yeah.
this issue of degeneration is reviewed with her. She had carried out her own experiments herself with GFAB staining. And she was saying that exposure up to 48 hours unfixed, there could still be sufficient time to extend it out to the time when no more cells could be identified. And she referred to microscope sections of the lamb's spinal cord, which is what she used for her experiments. That shows degenerative changes becoming more severe with time. Is that correct? Answer, it shows degenerative changes in the lipid. And do you see any such changes in the brain tissue prepared by Dr. Miller and shown on the screen, yes or no? There are no degenerative changes. They are only... I don't quite understand that.
No, but read on.
And on the slide that you prepared, I think we saw changes around the edges of the tissue, and you said it was damage due to drying. Is that right? Yes, that's correct. Do you see such damage due to drying on the section prepared by Dr. Miller? Yes or no? No, not as demonstrated. Do you regard the brain tissue prepared by Dr. Miller as being easily recognisable as brain? Yes, it was. Would it be correct then from a histological perspective that this tissue has been well fixed? It has been well fixed. Well, based on all those answers, is it correct to say that there is no histological evidence whatsoever in Dr. Miller's preparation that the brain tissue has been subjected to prolonged drying and degeneration? Given the stains provided, the answer is no, there is no degeneration as provided. That means it hasn't been subjected to prolonged drying and degeneration, does it? In the tissues provided, there is no evidence of that. So I do repeat the submission I made. This 59 days is a red herring in my submission. The issue is the time at which the tissue was fixed. It was serendipitous that it was fixed, but it was fixed using the same mechanism that is used by brain surgeons or other surgeons who take biopsies in the course of the theatre. The same concerns of getting it to the lab quickly, ensuring that it's fixed. The evidence given by a number of the pathologists about how they receive samples that suffer from degeneration in the normal course of work. Perhaps if I could take your lordships to Temple Camps. He discusses this in his evidence at pages 1213 through to 1216. this was his evidence, of course, that he was giving in relation to this issue of how long could the tissue survive and be able to be the subject of proper analysis after it had left the body. I won't take your worships through all that, but it is a detailed resume or detailed explanation of the way in which samples must be preserved immediately upon leaving the body, how essential that is in order for the pathologist to be able to draw any conclusions from the tissue sample, and how rapidly tissue breaks down if it is not fixed, if it is not preserved. And Dr. Temple Camp, in his affidavit at volume 5, page 2528,
I missed the reference.
page 2528.
Thank you very much.
This is in tab 17. Tab 17, I think it is. And, 2528. Oh, 2528. Beg your pardon.
2528? I'm sorry, it can't be 2528.
No, it can't be. No, that was Miller I was looking at.
2337, I'm being informed. Yeah, that's the affidavit.
2347.
Can I say 2342, paragraphs 18 and paragraphs 19. So he is speaking of how, in his day-to-day work, one has to deal with this natural occurrence. It's part and parcel of being a histopathologist.
It's interesting that he's indicating that the deeper the sample, the more the degeneration, so that I'm just thinking about that in terms of the ESR slide, of which there's quite a lot of evidence that it was not particularly satisfactory. I know there is some other evidence to the contrary. And our speculation that Dr. Miller's deeper cuts might have yielded better material. This suggests that actually the surface is more stable.
Oh, to formalin.
To formalin, but one would have thought that air drying would be... No?
Certainly the contest at trial was that it may have been possible, or the theory was that if it had been planted or if it had got on there accidentally, it was a larger amount of brain which could still have been preserved in a larger size, as opposed to the emphasis on the thin smear which allows for rapid air drying fixing.
Can we just see what point we're on at the moment, Mr. Maunder? We're on the, as I understand it, on the what you can tell from looking at, as distinct from the IHC testing, looking at the recovered material.
Yes.
So it doesn't go to the contest between Miller and Gowan on the one hand, and Sheard and Gatter and Whitwell on the other, as to whether IHC is a legitimate technique or not.
No.
This goes to what? Does it go to, are you asking us to say that there was sufficient evidence of identification of brain tissue independently of the IHC, or are you simply dealing with the impact of the non-disclosure of Dr. Tio's opinion?
Well, I suspect the latter, because
Right.
the accent is being placed upon his advice of degeneration,
Yes.
as if that's something that, if it had been known at the time, it would have alerted the defence. But it was always in play, it was always known. It was a factor that was apparent clearly to the defence.
Well, you say, as I understand it, that the answer to the question of what impact, if any, the non-disclosure of Dr. Tio's view over the telephone or wherever it is that Dr. Sinek was absolutely clear that what she was looking at was brain.
Indeed.
Paragraph 21 of the page 2342 to 2343 seems to indicate that there were areas of degeneration. And it wasn't as if it was a uniform pattern. And he's saying, well, forget about the degenerated bits. They don't indicate either yes or no. They just simply leave them out of account. But he could find undegenerated bits, which gave the indication that it was brain tissue.
Yes.
I think that's what he's saying. Now that is his. Is this visual, or is it what he's deducing from the slide?
Histological visual.
Visual
Form of the sample. So in my submission, what Dr. Templekamp is saying here is we deal with these types of samples every day. We look at the best preserved part of the sample. We discard the areas that have deteriorated and degenerated. We know we can't use those. And it's the very stuff of being a histopathologist in my submission.
Which slices from the paraffin blocks?
Yes, just because there is a little bit of tension or dispute about it, I just wish to confirm that Dr. Venesi's got freshly prepared cut slides from the paraffin blocks prepared by Dr. Miller. That is what Dr. Venesi's received. Unless there are any other points, I'm mindful of.
I think we're all right. I think we should move on. There's quite a lot more ground to cover, and I don't know whether you've agreed with Mr. Hislop when you should finish so that he can reply. Have you a target time for that?
I'm working towards a lunchtime
Right. Okay.
deadline.
Well, yes. Well, let's proceed. Thanks very much.
Attempting to anyway, my
Yes.
Lord. So perhaps if I can move then to the next ground of the appeal, which is the stomach contents and time of death. And can I commence on this topic by summarising the respondent's position in response to the appellant's arguments. Firstly, Mr. Behrens, in my submission, was very much alive to the scientific issues surrounding the use of stomach contents in the absence of gastric smell to estimate probable time of death. That does not seem to be in dispute. He consulted with at least 3 experts on the subject. In the respondent's submission, Mr. Behrens made a conscious, tactical decision not to call evidence, but rather to cross-examine the Crown's experts in reliance on the expert assistance that he had received. The decision was one which, in my submission, another reasonably competent counsel could well have made in the circumstances. Essentially, counsel sought to commit the Crown to a particular time frame in the presentation of its case, or at least why sought to keep it committed to the way it had chosen to frame and present its circumstantial case. The gains to be made by calling evidence were outweighed by the risk that the appellant's conduct would be considered against a wider time frame of death, less favourable to the defence case. The appellant's new evidence is not fresh. It doesn't, in my submission, purport to be fresh. It does not add appreciably to the evidence available and which was utilised by the appellant at trial. In my submission, it is therefore not necessary for the Board to resolve the apparent conflict in the expert opinion, such as it is, because this ground turns on an objective assessment of a tactical decision. The respondent submits that the conflict, when examined closely, is perhaps not as significant as the appellant maintains. On the Crown's 7 p.m. time of death theory, it is not disputed that the stomach contents sits within what could be expected under normal circumstances. It is not excluded. The appellant's post 10:52 p.m. theory, the time of the computer shutdown, requires, in my submission, either the deceased to have delayed consumption of their takeaway meal until later in the night, or that the normal digestive process of both deceased with some unknown reason, albeit it might be within the parameters, delayed for several hours. The question that arises is, had Mr. Behrens called the evidence, deployed the evidence, what was the extent of the mileage that the Crown could have got out of cross-examining these experts and pinning them down to what is more reasonable, more likely, more realistic? Now, it is correct that the time of death evidence was put forward at the commencement of the trial as a positive plank in the Crown case. But equally in my submission, it is apparent that by the end of the trial, it could no longer do so. It is hardly mentioned in the Crown's closing address. And perhaps it is worthwhile going to that. It is in the appellant's supplementary bundle.
Tab 1, I think.
Tab 1, yep, sir. At page 37, and in fact arises in the discussion of Mrs. Dance's evidence. About 2/3 of the way down that page, the learned prosecutor states, "Remember, members of the jury, it is not the evidence of Mrs. Dance alone that proves the time of death. It is not the evidence of Mrs. Dance alone which proves the accused was not in Petone at the time. It is in fact the other way around. The evidence of the time of death and the manipulation of the computer provide a degree of reliability and credence to her evidence overall. And you might take from it what you want, Mr. Foreman and members of the jury. You don't have to accept it all, but the timing of her observations is right. And then it goes on about Mrs. Dance's evidence. Now, that is the only reference in the Crown's closing, a 42-page document. And that is the only reference in the context of the whole closing. Not, of course, the defence is highly critical of this evidence, and in his closing address at tab 2, page 57 of the bundle through to 58, Mr. Behrens refers to the evidence of Dr. Pang. He refers to the complete absence of any literature, and he reminds the jury of the event whereby Dr. Pang was recalled to the witness box to be effectively exposed as that there was no literature on the point. Now, notwithstanding the Crown in its closing having placed almost no reliance on this evidence, the judge summed up by reference to the Crown's stipulated time of death of between 5:30 and 7:30 p.m. Mr. Behrens had achieved the very thing he wished for. He had undermined the time of death evidence as a positive plank that could be relied upon by the Crown, but preserved the tight time frame which suited his defence.
Sorry, Mr. Bronte, go on.
In my submission, it was a skillful piece of judgment by a highly experienced criminal counsel who had confidence to utilise the expert knowledge he had equipped himself with in a way that would provide the best outcome for the defence, having regard to the overall circumstantial case which his client faced. And that really, in a nutshell, is the Crown's position on this ground.
Do we get out of page 58 from Mr. Behrens' speech that he was contending to the jury that he'd exploded Dr. Pang's evidence, at least in relation to the smell, challenged him to produce some evidence from the books, asked him to come back and bring them, and he hadn't been able to?
Indeed.
That was the Behrens line.
It was.
I see.
And of course, without having to... Well, of course, that had an immediate effect on Professor Barbert's evidence as well.
Yeah.
So are you saying when you look at the top of page 58, along with the bottom of page 57, he's making these propositions secure in the knowledge that there hadn't been any exploration as to any later time? That hadn't really been an issue. He's trying to say, well, discount this evidence because of the smell point and so on, and then look at the other factors and discount them as well. But this is a nice, neatly packaged point.
Indeed.
Which he's disposing of on a very limited basis. Is that your point, really?
In my submission it is, my lord.
He's actually using the doubt about the time of death as a support for his case.
Indeed.
And he can only do that if he's got the Crown committed to 7 o'clock.
Yeah.
Yeah, I see.
And the Crown plainly are committed to 7 o'clock. There are several pages in the Crown's closing devoted to that, and really once and telling the jury that it's the time of death proves the computer can't be right, for example. And the starting point is the time of death is established to be about 7 o'clock at the midpoint of the window of opportunity for the appellant.
Indeed, my lord. Mr. Behrens's cross-examination, and I won't take your lordships through it all, but it's at pages 948 through to 958. But it is a highly effective cross-examination in my submission. He succeeds. While Dr. Pang's evidence is somewhat difficult to follow, he clearly, in his cross-examination, has Dr. Pang out to 3 hours and acknowledging 3 hours. He also has Dr. Pang acknowledging that, well, when it gets into the specifics, I'll defer to the physiologists. And of course, as has already been alluded to, the lack of any literature in relation to the gastric smell was lit up in lights when Dr. Pang was recalled. So, the risk of repeating myself, the appellant had available to him the material which is now put forward as fresh evidence, but the appellant's counsel utilised and deployed that information in a manner that was bespoke of the defence and the case which the defence had to meet. Now, post-trial, Mr. Behrens is criticised because he didn't put all the evidence wholesale in front of the jury. But as has already been alluded to in the course of this hearing, and as indeed Mr. Behrens himself in his statement specifically refers, whatever criticisms could be made and validated of Dr. Pang, the stomach contents evidence still remained consistent with death occurring within an hour of ingestion, such time frame being within the wider variable period. And Dr. Stables had given him that advice. I do not understand any of the expert evidence that's been tendered for the purposes of the appeal to be saying otherwise.
So your point is that whatever might be said of it, it's not inconsistent with the case that the Crown was seeking to make.
And indeed, if one gets into the detail of it, we can criticise the accuracy of Dr. Pang's note-taking and what have you, but his evidence as the pathologist who performed the post-mortem was that the stomach was quite full, containing a large meal. Small intestines of both deceased were empty.
Well, the only bit that's empty is the duodenum, and if Professor Diamond is right, it usually is.
Yes, indeed, and Dr. Barbizet gave evidence on that.
Anyway.
And described how, yes, by the very nature, the mechanism of the way the stomach functions, little pieces of food will go into the duodenum in a particular form because it's It's deciding whether or not the meal is sufficiently digested for the stomach to empty. So Dr. Barbizet, in terms of that mechanism, was cross-examined about that, and he accepted and acknowledged in his evidence that that was the case. But his evidence was, he thought that it perhaps wasn't surprising that Dr. Pang had missed that, given that it is of a very small amount. In any case, the submission that I make is that these various factors would be put to these experts for their comment as to if they were prepared, in their professional opinion, to put it on a timescale, at what end would they put it? And mindful that the experts on appeal give evidence about stomach emptying, whereas the evidence that was being given at trial was very much about the first stage in the process, the lag, what's described as the lag stage before the stomach empties. Perhaps it is worth also just considering what the counterfactual is here. If the appellant had called Dr. Staples and Professor Vanesis to give this type of evidence, in my submission there could have been three potential effects. Firstly, 7 p.m. remained a reasonable candidate for time of death, as neither witness could exclude it. The indicators in favour of it remained intact, notwithstanding the criticism that could be made that they were not absolutes by any means. Secondly, as a result, the Crown might accept the need for greater flexibility in its approach to this aspect of the case, resulting in it no longer committing itself solely to the 7 p.m. scenario. Thirdly, the Crown could no longer, as a positive plank of its case, rely on Pang and Barbizet being so precise as to a 1 hour time frame. But in my submission, Defence Counsel was entitled to believe that as a result of his cross-examination, he had achieved that. And what then was to be gained by calling the evidence available to him on the issue? And it's my submission that one looks at the Crown's use of this evidence in its closing, it is readily apparent that Mr. Behrens had achieved what he set out to do.
I'm not sure he can be said to have achieved what he set out to do. What he set out to do was to create a reasonable doubt in the minds of the jury that the killing occurred at the time the Crown said that it did. And it's quite clear that the jury must have concluded beyond reasonable doubt that it did occur in the time frame, because they were given explicit direction by the judge to that effect.
No doubt, but that of course takes one back to the brain that would have to be explained on the appellant's shirt.
Yes, but the judge given an express direction to the jury, which we must assume they followed, that unless they were satisfied that the killing occurred within the short window, then there was a reasonable doubt as to the appellant's guilt, and he must be acquitted. So they must have concluded. So Mr. Behrens didn't succeed in his objective.
No, he didn't succeed in his ultimate objective, but in my submission, as he was positioned himself before addressing the jury, putting his best foot forward.
Well, I think what you would
Yes.
say is this is a classic case of relitigation. At the time a forensic decision was made, well, I've done as well as I could possibly hope to, and I reach a tactical view. Look, don't put my witnesses in because they may agree that it is feasible that the time of death was as the Crown claimed it to be. So you're saying this is really a classic case of relitigation. Wherever the scales go in relation to this business that I put to you yesterday, whether it's the possibility of miscarriage of justice trumps the one trial principle, you say that this is a classic case of one trial principle applying.
I do, my lord.
Yeah.
Unless the
Well,
board
I
has
think we
any
can move on to the
further.
next point. Is that computer evidence? Computer
Yes,
shutdown.
In relation to this ground, computer shutdown time, the Crown's submissions on this start at its case at page 4021.
Is this your paragraph 153 and onwards? Are you talking about your written case?
253.
Yes, page 4121
Sorry,
in the Crown
253.
case.
253, beg your pardon. Yeah.
The page 69,
Yes.
ground 5.
Yep.
Now, in my submission, there's common ground that the appellant could have manipulated the computer clock so as to make it appear falsely that the computer was shut down at 10:52 p.m. because that is what you can do on a computer. What is an issue is the validity of the supporting evidence in the form of Mr. Kleinschy's trial opinion that the disorder in the computer's registry files could have been caused by previous manipulation of the computer time, date, settings, giving rise to the possibility of experimentation on the appellant's part. As matters presently stand, the appellant says that the disorder was caused by a computer virus. Mr. Kleinschy's, in his evidence, disputes this. Now, the existence of the virus and its possible or potential effect on the registry files was known by the appellant at the time of trial. Mr. Kleinschy's was cross-examined on this and other possible explanations with a defence expert present and available to him in the courtroom. Mr. Barron's reasons for not calling the expert are somewhat unclear on the available material, but in the respondent's submission, the hypothesis put forward by the appellant, which does not seem to have been pursued in oral argument, that Mr. Peacock, the defence trial expert, wrongly drew a conclusion adverse to the appellant, is in my submission not borne out on the appellant's disclosure. Ultimately, the cause of the registry files disorder is contentious, and resolution would appear to require cross-examination of the experts as well as additional evidence.
The Crown disputes the evidence now put forward, does it, by Mr. Watt?
It does. Mr. Kleinschy's affidavit is that he carried out his own experiments, and he doesn't. He refutes. He refutes the evidence put forward by Mr. Watt that the virus, the CAC virus, disorders the registry files.
So he's not disputing that a virus is present?
No.
It's the effect of it that's the point, is it?
Indeed, my lord.
The evidence about disorder of files was only ever supportive evidence, was it, of the prosecution case that the computer time had been manipulated?
That's all it was. In fact, all it was an attempt to draw an inference that because the registry files were disordered, there had been some form of experimentation at some earlier stage.
You say it's all it was. It was actually presented as a telltale sign that something sinister had been going on, wasn't it?
Yes,
Well, I don't wish to be disingenuous in terms of how
You
the
are
crowd...
members of the jury. We've got clear side footprint left on the computer that something sinister's been going on.
Yeah, but it was of critical importance because the time of death had to be 7 o'clock. That implied that the computer time couldn't be right, and the only indication that somebody had been fiddling with the computer was the registry files being in the state they were.
Well, in my submission, the crowd, my lord, is totally correct. The computer shutdown time was a stumbling block for the Crown on its 7 o'clock theory. But the evidence of Mr. Kleincheese was to say, well, you can alter the computer, you can set up a fictitious shutdown time, but at trial, Mr. Kleincheese accepted that changing the time did not disorder the files, that you had to change the date as well. And so therefore, Mr. Kleincheese could not give evidence to say that, well, the Crown is saying he's altered the time, he's put the time of shutdown forward, and look at the registry files, they're disordered. That proves, therefore, that's what he's done. It could not be put on that basis. It could only be put on, oh, there's something going on here because the registry files are out of order, and that must mean that someone's been playing around with the clock and the dates and the times. And Mr. Kleinchee's evidence was that at least on 5 previous occasions, someone must have been fiddling with the control panel as far as it affects time and date. But he accepted the date has to change. That's something which has to be altered in order for the registry files to get date out of order. And that's what we're talking about.
We get a presentation of it in the speech for the Crown, I think at page 34, if I got it correctly, in the supplementary bundle, tab 1, where it was being put to the jury, and there'd been some experimenting going on, and so Kleincheese was saying, and the question for the jury was who would do it. But is the point that it would have to be changed to change the time on this particular day, something done on this particular day? I mean, this is what he seems to be saying, that the computer was altered between 3:40 and shortly after the 6:56 phone call. I mean, that seems to be the inference that they're being asked to draw.
Well, in my submission, the learned prosecutor refers to experimentation. Mm-hmm. I suggest, and there's a disconnect there. I suggest and I suspect it should record. I suggest an experimentation. There is a difficulty with this transcript. It's not an official court transcript.
I see.
My learned friends have done their best to obtain the. It's been sourced from the media.
Well, apparently there was a television recording.
Yes.
And it's been taken from the television recording.
It has.
there was some suggestion that you weren't able to play the material.
Well, it needed a VHS.
Surely that's... Have you not played it? I mean, has the respondent not played this yet?
No, we haven't been able to. We got it relatively recently. I don't put that forward as an excuse, but I just pointed out to the board the provenance of the document, because I've just picked up the...
Let me try to understand then what the Crown's case resolved to finally. It was that although the disarray of the files did not indicate that the time had been changed, it did indicate that someone, to use your language, had been playing about with the computer.
Yes.
Yeah.
That an inference could be drawn that someone has been practicing, someone has been looking at what happens, why else have the registry files been got out of order. The difficulty always for the Crown was that you had to alter the date.
Yes, but the Crown case went further, did it not, in that Mr. Clancy's asserted positively that the CAG virus could not have caused the disarray.
Well, he certainly, I suppose, poured scorn on the idea. He said it was possible, but unlikely, and he said there had been, incorrectly, he said there's a virus checking program, but the virus checking program was out of date, as it turned out.
He left the jury with the impression that there wasn't a virus, didn't he?
He did.
Because of the virus check.
He did.
In other words, he was saying that the virus had not caused this.
Well, in effect, he was discounting a virus as being the source.
And I'm not sure that there's much difference between saying that the virus hadn't caused it and discounting the virus as the source. But be that as it may, that was in fact incorrect evidence, wasn't it?
No, well, we haven't reached that point, because that certainly is the appellant's expert's view. Mr. Kleinschie's, who has sworn an affidavit, says he's carried out his own tests recently for the purposes of this appeal, and he says it does not have that effect.
Well, you're going to deal with the submissions of Mr. Hislop to contrary effect, I'm sure. So I'll not anticipate those.
It may be worthwhile at this point just to specifically go to the point that was raised by my learned friend by reference to Mr. Watt's affidavit. This is at volume 6, tab 29. At page 2459. Now, there was some discussion about this yesterday, and I believe it's accurate to submit that we got to the point where no actual expert from the appellant is actually specifically referring to these pages and what they actually interpret. I have made inquiries overnight of Mr. Kleinschie's, and I am in danger of giving evidence from the bar, but just to exhibit the fact that we don't know what this means. The respondent would dispute the interpretation that was provided by my learned friend from the bar.
So you don't accept that the fact that RB004 has the date 29th of August and the file number RB005 has the date of the 28th of August shows that the files are in disarray? or disordered, I should put it that way.
No, they show the files have been disarrayed. The question that arises is at the top of the page, screenshot for virus settings, not for email. The question is, what are we looking at? Are we looking at what has been lifted from the clone of the Lundy file as it presented at the time it was captured, set out here, or are we looking at Mr. Kleinsch's test results? Now, it was put forward that we were looking yesterday at Mr. Kleinsch's test results.
Well, I mean, the top of the page rather suggests that, but I don't know quite where we're going. I mean, it said screenshot for various settings.
I'm sorry, that perhaps wasn't very helpful. What I'm alluding to is where does it say what we are looking at here? Where has this come from? And the suggestion that was being made yesterday was this is the results of Mr. Kleinsch's testing. I dispute that.
You accept, or do you accept that these are Kleinsch's papers?
They are Kleinsch's papers, who has gone to the cloned Lundy computer.
Yeah.
And I guess I'm not really saying what, with my submission, this is not the result of the test.
Well, he's telling us a little bit about what he was doing at the bottom of page 2458.
Yes.
We exported
Yes.
certain files and noted the following, and I rather understood that what we're seeing here is what he noted.
And noted from, he exports it. Where has he exported it from? And then he makes the note of what has been exported.
Yeah.
I have to say, my lord, I'm sort of dancing around because I haven't got the witness here to give the evidence.
I see.
All I can submit is that it has not accepted the interpretation of the note that was put forward by my learned friend yesterday.
Is there a typing error in the sentence we exported the existing non-overwritten CAB files? RB004 seems to appear twice. Should the final one be RB005?
I'm sorry.
You don't know.
I can't take that any further.
How's this exhibit described in the affidavit? I'm just trying to look for the place. I suppose it's not in dispute that it's Mr. Kleinsch's notes.
Uh, 12B,
12B.
page 2410.
Thank you.
It's in paragraph 12 of the body of the affidavit. That's at page 2410.
I see. Thank you.
Yes. Yeah.
Now, it was the appellant's eagerness to suggest that the police, and this is relevant to the next ground of appeal relating to the laptop, so it's probably worthwhile going to it. It's in the page 1561 of the bundle.
Is that volume 4?
Volume 4.
I guess.
the appellant refers to 1561 tab 6 of volume
I don't
4.
have that numbering.
This is an interview with the
Yes.
appellant.
Yes.
What's the date of the interview, please, Mr.
The date of the interview is
Morn? Is it on 1519, 14th of September, or is that a guess?
oh, that's
Right,
correct. my
That's
lord.
correct. So, just while we're thinking of that, the murder is the 29th of
29th of
August. Is this under caution, or is this a witness interview?
I believe
Looks like
it's
a witness interview.
It's a witness interview.
So he's being interviewed as a witness rather than a
Yes.
suspect.
Yes.
He's not under caution, is he?
He's not under caution, no.
Well, I'm
Having
not sure
previous-
about the
Sorry.
disorder of the files, but my pages are disordered.
I apologise.
No, that's right. Just tell me the number again and I'll find it. They're back to front.
1561.
Thank you.
I understand that there may be some copies that suffer from that.
Yeah.
It's in the typed interview. Page 43 is the internal number.
Oh, 43. Okay, I'll see if I can find it. That's all back to front. 43 here. Yes, thank you.
You got that?
Yes.
Does it have 1561?
Yes, it does. It does.
Yes, I think we're all right.
Let's have a virus.
Yes.
So this is him being interviewed about his wife's habits at bedtime, basically, isn't it? And
It commences from there.
Yes.
Talking about Mrs. Lundy's habits in the evening.
Yep.
And is your computer one that's turned on or off all the time? It's turned off, it's turned on in the morning, electronically. The appellant says, no, we go and do it. So when the computer was turned off, I would say, because you can tell when computers are turned off, can't you? Or computer people can, I can't, hopeless. Detective says, don't know. It could be traced when the computer was turned off. I would say that's when Christine went to bed, because it's nearly always the last thing done when we go to bed. Check the emails, turn the computer off. Yeah, damn, why didn't I think of that before? What's the significance of that? Well, it's like you need to know what happened. And I'm sure that would give Christine a time when she went to bed. Well, that's if the computer was turned off, it would be sure. If it was turned off, like on the Tuesday night? Yeah, I would say Christine turned that computer off and then went to bed. So if the computer guys can say, yeah, it was last turned off as such, in such a time, then that would be the time that she went to bed. The detective says, unless she turned it off at close of business for the day, whatever. Appellant said, no, I wouldn't do it, never does. So it's basically always turned off when we go to bed because we always check for emails at night. So the computer was then checked and the clock recorded 10:52 p.m. Now, Mr. Kleinche's evidence, apart from describing what he found on his examination, was to explain the methods by which a person can change the time without leaving any record. And he described two methods, one whereby before the computer gets into operational mode, it's in setup mode, and if you press a key, you get up into setup mode and you're able to change the time without leaving any type of forensic mark or recording. Second means was by introducing a second time and date control panel via a floppy disk and using that to change the time or date. And it was by those means that it was proffered to the jury as potential means by which the computer could be changed. This was demonstrated by the witness in front of the jury. Now, while none of those actions are inherently difficult to perform, obviously they do require a degree of knowledge. It is to be noted that the appellant was keen to impress upon police his lack of computer expertise when he made the suggestion they check the computer shutdown time. Mr. Kleinches examined the computer and found that the registry or backup files were disordered, and to Mr. Kleinches that exhibited, quote, extensive manipulation, unquote, of the time and date. He said that an adjustment of 1 or 2 minutes would not have resulted in the files becoming disordered. Also, he gave evidence, which I don't understand to be disputed, that the computer showed no sign of use from 3:40 p.m. until its shutdown. And Mr. Peacock, in his report at page 2113 of the bundle, agreed with that. Given the evidence, including from the appellant, that Christine often used the computer in the evenings after Amber went to bed, the lack of evidence of computer activity, apart from shutdown, could be interpreted as supporting an earlier time of death. Now, we know that Mr. Behrens engaged a computer engineer, Mr. Peacock, that his report is annexed to the affidavit of Mr. Chappell's, and that can be found in volume 5 at tab 16. Line 2097. Got 5 of them. Now, Mr. Peacock.
Could you give the page number again, please?
I'm sorry.
Is it page 2107?
It is.
Right.
Thank you, my lord.
So this is his comment on Mr. Clench's.
That's correct, my lord. And perhaps we should also just note his follow-up report, which is on page 2125, to complete what his final advice was. Now, Mr. Peacock agreed that the time date could have been manipulated using the methods discussed by Mr. Kleinches. He disagreed that the floppy disk method would not leave a trace. He said the registry files would become disordered due to manipulation only if the date was changed, not just the time. And he said the disordered files were a common phenomena attributable to program errors, especially with older computer games, viruses, depleted batteries, human error. And he says that at 2128. Sorry. 2108 under the heading Registry Backup Files.
Yes.
It's to be noted that Mr. Peacock referred to computer viruses being a potential source. He also located the presence of the virus, the cat email worm, and noted its potential effect on the registry files. And he attached, as an appendix at page 2121, what appears to be a piece of information from the internet about the CAC file and its effect. The first paragraph states it alters a file that your computer uses whenever you send out an email message or newsgroup posting, so that every message that goes out has the virus attached to it. It does not corrupt any data on your hard drive. However, it is designed to shut your machine down on certain days, which may inadvertently result in a loss of data.
I notice at page 2108 at the bottom, he is saying that it's possible that the registry files have been out of order for at least 5 months.
Yes.
Prior to the date in question. So,
Yes.
I mean, it could be that we don't know because nobody asked the question. That there'd been something wrong with the timing on this for some time.
Oh, yes, and my recollection is that that was put.
Oh, was it? Right.
Yes. However, Mr. Peacock, his conclusion, firstly at 2107, was that in the third paragraph under the heading usage, it is technically possible that the system clock was adjusted by the second method proposed by Mr. Kleincheese at some time after 1540 to give an apparent shutdown time of 22:52 p.m. And in his later correspondence at page 2125, under the heading Command Prompt Method of Data Change, third paragraph down, as I cannot find any file modification times between 1540 and 2251 on the day of the murder, it is entirely possible that the computer clock could have been manipulated at any time after 1540. So it was put about how long the registry files could have been disordered, and the reference of that is the cross-examination at page 1129.
Thank you very much.
I have alluded to the fact that Mr. Behrens' statement doesn't cast a great deal of light, perhaps, on why he did not call Mr. Peacock. He believed the genesis of that decision may have been a discussion he had during the course of cross-examination of Mr. Kleincheese. But it has to be noted in my submission that if Mr. Peacock had been called, he would have been a second computer expert who would have agreed that it was, quote, entirely possible, unquote, for the appellant to have manipulated the computer clock. So Mr. Behrens would have to live with calling an expert who would confirm what essentially was Mr. Kleincheese' evidence that you can manipulate computer clocks. In cross-examination, Mr. Kleincheese obtained the following concessions. These are set out in the Crown's case at paragraphs 270 through 271. And perhaps if I can take you to the evidence itself, page 1125.
In volume 3, are we for that?
Yes. 26. Backup files of the registry are out of order, that's right. Would you agree with me that they only become out of order if dates are changed? Correct. So therefore, if someone went into the computer and practiced what you have described shown to have been done, as he had demonstrated in his examination in chief, the changing of the time, and they did it within one day, there would be no mixing up of the backup files. Correct.
Yes, so he wasn't merely saying that it was possible to alter the timing on the computer. I mean, he's saying that the implication of the disordered state of a registry is that somebody has done this.
Sorry?
He's saying, isn't he, that on the passage you took us to first, would you agree that they only become out of order if dates are changed? So it's only if somebody is fiddling around with the time and dates on the computer that you would find what he found, that the registry files were in disordered state.
Well, that was certainly a hypothesis that Mr. Kleingees was putting up.
Yeah. Well, he's saying that's his evidence, isn't it? Lines 28 and 29 on page 1125.
Yes, if the dates are changed. He agreed and accepted that the 10:52 time could be correct. That's at page 1124. That a person might attempt to change the date on the computer for innocent reasons. That's at page 1128 through to 29. Line 17, could the date have been changed if someone was trying to avoid the onset of the millennium? I understand this machine was year 2000 compliant, but couldn't you put the clock back or something like that to avoid January 1 coming around? Couldn't you? Could a person affect the backup registry by changing the date in order to affect compliance with an accounting deadline? That's possible, although most accounting programs are clever enough. And he's further cross-examined on the point. He's cross-examined at line 20 on page 1129. So it's commencing at line 16. Now, would you agree with me that the fact that the files are out of order in the way we're talking about simply means that at some time prior to when you looked, the date was changed? Yes, that's right. And there's no way, is there, to tell when that might have happened? No, once they're out of order, they stay out of order. So it could have happened many months before the 29th of August. Answer, definitely. It was put to him that the floppy disk method left a trace, but he denied that, sticking to his evidence in chief. Now, the appellant's new evidence that's put before the appeal court, the key part of their evidence is their opinion that the CAC virus was the cause of the disorder of the registry files, as distinct to Mr. Peacock's advice that it was a potential cause. And that opinion is offered on the basis of test findings that were being carried out by the appellant's experts. Mr. Kleingees, in his affidavit, acknowledges that the CAC virus affects the registry files, but he denies that it affects the order. And he is critical of the appellant's experts' methodology and for their apparent failure to perform what he describes as the, quote, obvious test, the deliberate infection of a clean computer with the CAC virus and a subsequent examination of the registry files. He deposes that he performed such tests and the registry files, while affected, did not become disordered. Mr. Chappell, while the first expert for the appellant, Mr. Chappell has expressed the opinion that the floppy disk method does not leave a detectable trace. Dr. Watt, the second expert for the appellant, does not agree.
As a trace of use by the floppy disk, I mean.
Yes, and Dr. Watt's opinion is that no, he agrees with Mr. Kleincheese, it wouldn't leave a trace.
Would not.
Would not.
No.
Sorry, Chappell says that the floppy disk
Would leave a trace?
would leave a trace.
Yeah.
And Watt says it wouldn't.
And it's probably worthwhile going to Mr. Watt's evidence, which I think is in volume 6, at page 2411. That's at tab 29, volume 6, 2411. Paragraph 17, which is at the bottom of the page. Halfway through that paragraph, having criticised the use of the term manipulation by Mr. Kleincheese in his evidence, he says, that said, I have never disagreed with Mr. Kleincheese that time shutdown time can be manipulated without leaving a trace. However, again, Mr. Kleincheese has mentioned time only, and in this case the rollback files would not be affected, as would be the case if the appellant had practiced changing the time as is suggested. Well, in fact, in my submission, that was the evidence that he gave at trial, that the date had to be changed. Paragraph 18, more generally, I agree that the method suggested by Mr. Kleincheese at trial does not leave any trace.
That's the disk point. Yep. All right.
And then he goes on to talk about, well, there's no positive evidence that the clock was changed. And that's correct. And the Crown evidence was offered purely as information to the jury that you can do this. So in my submission, the new evidence is not fresh. Plainly, it was discoverable at the time of trial. The new evidence is in the nature of an augmentation of the evidence available to the defence at trial, and this generally is not admissible. Mr. Peacock had identified the virus and its potential effect on the registry, but he, like the evidence of Dr. Watt, now sought to be admitted as fresh, accepted that the computer clock could be changed without leaving a trace. The appellant's case is not improved on this essential question. On the issue of the registry files, on appeal, we have a dispute between experts as to whether or not the CAC virus affects the order of the registry files or not. The assertion that Mr. Behrens was misled by Mr. Peacock's wrong opinion regarding, I haven't covered this with your lordships, my lady. Perhaps if I can just refer the board to the paragraphs in the Crown's case, paragraphs 266 through to 269, which discuss this point.
Yes. Yes.
And the Crown submits that Mr. Peacock was not labouring under any error as to the automatic access of the command.com file as appears from his initial report. Initially, that's what he was saying, but in his subsequent report 2125 in volume 5, that's tab 16, under the heading Command Prompt Method of Data Change, the last paragraph, Mr. Peacock says the access time on the file c:/command.com appears to be updated every time the Lundy computer is turned on as a result of an antivirus program. Therefore, it is not possible to tell if this copy of the command prompt was used for any other purposes. Initially, he was concerned that the command.com file had been accessed, and he thought there should be no reason why that should have been accessed on the 29th. No innocent reason as to why that should have been accessed, but in fact, in his further work, he discovered that it actually automatically opened as a result of the antivirus program. So it wasn't. He was not misleading Mr. Behrens. He advised Mr. Behrens of his amended view. So therefore, the theory that is put forward in the appellant's case as to perhaps why Mr. Behrens did not call Mr. Peacock in my submission does not bear scrutiny.
Does this evidence mean, or does this finding mean that the prosecution was really left simply with the floppy disk method of manipulation, or did it still have an alternative?
It had both.
It had both.
It had the accessing the control panel while the computer was in startup mode.
Yes. Oh, yes, in startup mode. That's right. Yes.
In addition to the floppy disk.
Yeah.
Did anybody explore how long this would take to do? I mean, given the very narrow time frame, there's a lot of activity takes place on the Crown's theory. There's a break-in, obviously there's a murder, there's a clean-up, and all of that has all got to be packed into quite a short space of time. And I have no feel myself for how long this would take. I mean, the floppy disk might be very quick, I don't know.
The only reference I can provide to your lordship is the fact that no doubt the jury were aware of that consideration, and Mr. Kleincheese physically demonstrated what was required to be done in front of them.
I see.
And apparently, I'm advised by my learned junior, he also went through the keystrokes that were required to carry out the exercise.
Did he do both the floppy disk and the accessing?
Yes. Yes, he did. Of course, Mr. Behrens had available to him and questioned a number of witnesses about Mr. Lundy's computer intelligence and his level of know-how, and got a number of useful pieces of advice that Mr. Lundy was not particularly expert in computers, which indeed really corroborated what he had told the police. So Mr. Behrens was entitled to take the view that he had demonstrated to the jury that the appellant was not a person who would be expected to have the type of knowledge to carry out this type of manipulation. He was also entitled, Mr. Behrens, to conclude that the practicing or experimentation theory relating to the disordered registry files was never particularly realistic. because it required the dates to be manipulated, which was not what the Crown case had happened on the 29th, only the time. And indeed, because Mr. Kleincheese had accepted that the disordered files could have been on the computer for a long period of time, and had given various answers to the other propositions put forward in terms of innocent explanation. Can I move now to the, if your lordships, my lady, please, to the laptop.
Just before you leave this, we're left, are we, with a decision made by counsel, clearly deliberate because he's got Mr. Peacock there, not to call him, and no suggestion as to what the reason might have been.
No, only the one that I've offered, which is that Mr. Peacock would have to concede and accept under cross-examination that it was indeed possible.
Possible to do it without trace?
Yes. Can I move now, please, to the laptop issue?
No, the point here is a suppression of evidence, is it? The laptop wasn't preserved.
Yes, that's correct, my Lord. The allegation is that that the laptop was not preserved, and therefore the opportunity was lost to the defence to obtain vital evidence that might have been on the laptop, which could have been to the benefit of the appellant. In my submission, it should be noted that no issue has previously been raised as to the failure of the police to clone the appellant's laptop, neither pre-trial, at trial, or post-trial on appeal to the Court of Appeal, and I will allude to why in my submission that is likely the case. Prior to the trial, in my submission, there was ample opportunity for the defence to arrange for this to be done if it was thought critical. Indeed, it is apparent from the appellant's disclosure that the laptop drive was examined by a defence expert, Mr. Peacock, and nothing of significance noted. And perhaps it's worthwhile going straight to that. Again, returning to Mr. Peacock's reports in volume 5 of the bundle at page 2125. The submission that appears to be made by the appellant is that by the time the laptop became available to the defence, it was impossible for any proper forensic investigation. But in my submission, the only basis upon which such a submission could be made is that contained in Mr. Peacock's report at page 2125. The second paragraph of his letter, or first paragraph starting there, I have now full dated file listings for both the Lundy and laptop hard drives. Along with text extractions from these drives, I can search for specific words or phrases. Analysis of the laptop drive is complicated by the fact there is material relating to Simon Malcolm prior to Mark using this laptop, reference to the appellant, and the usage of the laptop since 29 August 2000. Now, the reference to Simon Malcolm is a friend of the appellant from whom the computer was sourced. And the usage after the laptop, the 29th of August, is the usage by the appellant when it was returned to him. if one then couples that with the interview of the 14th of September, when it was the appellant himself, and I've already taken the board to that passage, where it was the appellant himself who alerted the police to the significance.
Just give me the reference again, please.
1561.
1561, yes.
Who alerted the police to the significance of the computer shutdown time. It is apparent that the appellant was not ignorant of the potential significance, if any, of the laptop in my submission. And in my submission, the appellant was in no worse position, or no worse position than the police in terms of assessing the relevance or the import of the contents of the laptop. And indeed, it was returned to him, and the only problems associated with interrogating it were things that either before the time of the murders were in place anyway, use by a previous possessor, and use by the appellant after he'd come into possession of the item, having already informed the police about the significance of computers and their relevance.
I suppose if at the end of the day, if the laptop had been preserved or cloned, and if at best for the appellant it had shown usage of the laptop at some time after 7 o'clock that evening, the Crown's position would have been the same as it was in relation to the desktop, that there had been an undetectable method used to alter the time.
Yes.
Yeah.
Yes, my Lord.
So it doesn't matter how many computers there were, the argument's the same in relation to all of them.
If you do it for one, you'd have to be doing it for two. My learned friend has cited the case of Harmer, which is the leading New Zealand authority on the issue. And that case, or the most apposite passages of that case are set out in the Crown's case at paragraph 286. I won't read those passages out to your lordships, my lady. But in the case of Harmer, there were some 12 items of lost evidence, mainly relating to the failure by police to preserve the scene and preserve exhibits. The court accepted that undoubtedly there were deficiencies in the way in which the police investigation proceeded. That's at paragraph 85 of the judgment. However, it was, quote, entirely a matter of speculation, unquote, whether the defence might have gained assistance from the evidence in question. It was just as likely, if not more likely, that the evidence would have assisted the Crown. And in many respects, the position is the same here. We don't know. It is a matter of speculation. There has been some emphasis placed upon preparation by Mrs. Lundy of some GST returns for a relative. However, in my submission, the evidence is that the laptop, this is at paragraph 292 of the appellant's case, the appellant himself had told police that that while Christine may have wanted the laptop on Tuesday the 29th to carry out that task, that this was for the purpose of transposing her brother's company documents to the office computer. It was the office computer that was equipped with the relevant accounting software.
So you said paragraph 292.
It's off your case.
Sorry,
Of the respondent's case.
Yes, you said the appellant's case, but it's actually your case.
I apologise. 292 of the respondent's case.
Yeah.
And the part of the video interview of the 23rd of February 2001, which I'm referring to, is at page 1679. Sorry, 1461, as you were, my lords, my lady.
Is the explanation of what she was using it for precisely the important point? There does seem to be corroboration of the fact that she asked for the computer to be left for the purpose of doing the GST returns because her brother was expecting, had come around the next day, hadn't he, to
Yes.
To get it. So isn't that the issue as to, I'm not sure why you put such emphasis on whether it was just to transpose it.
Well, in terms of what actually would have been what the work that would have been carried out on. Perhaps if we go to the interview.
Oh, you mean that the work would have been carried on the office computer, so that's the last one that's likely to have been
Yes.
used? Yes.
That had the accounting
Yes, I
package
see.
on it,
I see.
which was to be utilised in order for. That's why she was
Yes.
being engaged to do the job. Sorry, I've been confused about the appropriate reference. The appropriate reference is the bundle at 1461.
This is his statement to the police.
Statement to police on the 30th of August. Volume 4. Volume 4, 1461, the third paragraph from the bottom of the page.
Now, this is a statement made on the 30th of August.
It is.
What stage we reached by then? Was he still a witness?
It's the day after, it's the Wednesday.
So he was under...
The appellant has returned that day
right.
to Palmerston North. And he states there...
Yes, he's in the police station. Indeed. Yeah. Right. So it's 1461.
1461, third paragraph from the bottom of the page.
Yeah.
My laptop should also be in the office that Christine wanted to use it yesterday. She was taking her brother's company books off the laptop and transposing them onto the new accounting package on the computer.
And the office computer that we're speaking about here is the desktop in the house, is it?
Yes, one of the rooms in the house was the office.
Yeah.
It's the 1059 shutdown computer.
Yes.
So your point is that's the evidence of shutdown.
Yes, indeed. And
Likely.
one has to say, well, why is it just not a matter of speculation as to what this evidence might be?
Mm-hmm.
My learned friends have attempted to point to that the work that she was to carry out that night is somehow providing some weight to the perhaps the importance of that evidence. My submission is, well, it won't take you that far at all in terms of the shutdown time because of this.
No, it's just on 1 o'clock, Mr. Lander. Is that a convenient point to break? You don't have much more to address us on, did you indicate?
No, I would only have the identification point, which I will deal with very shortly.
Right.
And then perhaps make a few submissions in relation to the balance of the Crown's case.
Right. Good, well, we'll come back at 2 o'clock.
Lordship speak.